Let me turn down the jazz. Hello, everyone. Welcome back to the rest. Try to get through the rest of the Colorado decision that disqualified Trump from being on the ballot for the GOP primary coming up in, I guess, on Super Tuesday in March. For continuity, I am back in my reindeer onesie. I didn't want to break up the fluidity of the thing, so we're going to continue on with that. The other thing that I'll say is I've decided, sorry if I'm looking off camera, I'm just still checking everything before we decide to run with it and hit play. Yesterday it was too much stress to try to anticipate like all of the long bits. So if I can do it easily, like if there's just like a long citation at the end of a sentence, then, yeah, Merry Christmas. Thank you to, is it Katie and Paul in the chat? Thank you for stopping by. So, yes, I'm also going to pull my mic back a little bit. I'm farther away, but I'm very loud. We're going to, so if it makes sense, if it's easy to do, I'm still going to skip the footnotes, but, and if possible to time it, I'll try to skip the page number reading out, but I'm just going to be way more chill than I was last time. So yeah, I guess that's it. We're going to have much shorter start. So with that, let's get on. We were on the subsection 3, the presidential oath is, do you need to watch part 1? I think that there's, all of these things are pretty independently stood. So if you just jump into this section now, chances are you're going to be able to understand it forward. If there's any part that really relies on prior sections, but you can watch this out of order. It's no problem, Katie. Schoolboy, who's that? Sorry, Scribby. Sorry, the pop-out chat is really far away, so maybe I can pop you all out so I can keep more of an eye on you this time. Yesterday I was using my phone to chat back with you, and so let me pop this out, and then we'll get started. All right, so there y'all are. I'll pull you over so I can check on you from time to time, and we're gonna hit play, and I'm gonna chill more, and let's just go.
3. The presidential oath is an oath to support the Constitution. Pilcrel 153. Finally, we consider whether the oath taken by the President to preserve, protect and defend the Constitution, U.S. Const. Art. 2, Section 1, CL. 8, is an oath to support the Constitution of the United States, id. At amend. 14, Section 3, the District Court found that, because the presidential oath's language is more particular than the oath referenced in Section 3, the drafters did not intend to include former presidents. Anderson, Pilcrow 313. We disagree. Pilcrow 154. Article VI of the Constitution provides that all executive and judicial officers of the United States shall be bound by oath or affirmation. 2. 84. Support this Constitution. 15 U.S. Const. Art. Vi. CL. 3. Article 2 specifies that the President shall swear an oath to preserve, protect and defend the Constitution, id. At Art. 2, Section 1, CL. 8. Interveners contend that because the Article 2 oath does not include a pledge to support the Constitution, an insurrectionist president cannot be disqualified from holding future office under Section 3 on the basis of that oath. Pilcrel 155. This argument fails because the President is an executive officer of the United States under Article VI, albeit one for whom a more specific oath is prescribed, id. At Art. Vi. CL. 3. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation, to support this Constitution. This conclusion follows logically from the accepted fact that the Vice President is also an executive officer. True, the Vice President takes the more general oath prescribed by federal law, see 5 U.S.C. Section 3331, noting that anyone except the President, elected or appointed to an office of honor or profit in the civil service or uniformed services, shall take an oath including a pledge to support and defend the Constitution. 15 Article VI, however, does not provide any specific form of oath or affirmation. 85. But it makes no sense to conclude that the Vice President is an executive officer under Article VI but the President is not. Pilcrel 156. The language of the presidential oath, a commitment to preserve, protect, and defend the Constitution, is consistent with the plain meaning of the word support. U.S. Const. Art. 2, Section 1, CL. 8. Modern dictionaries define support to include defend and vice versa. So did dictionaries from the time of Section 3's drafting. See, for example, Samuel Johnson, A Dictionary of the English Language, Defend, To Stand in Defense of, To Protect, To Support, Noah Webster, An American Dictionary of the English Language 271, Defend, To Support or Maintain, Pilker 157. The specific language of the presidential oath does not make it anything other than an oath to support the Constitution. Indeed, as one senator explained just a few years before Section 3's ratification, the language in oath of office, that he shall protect, support, and defend the Constitution, makes his obligation more emphatic and more obligatory, if possible. 86. Than ours, which is simply to support the Constitution. Cong. Globe, 37th Cong, 3d Sess. 89. And, in fact, several 19th century presidents referred to the presidential oath as an oath to support the Constitution. See James D. Richardson, A Compilation of the Messages and Papers of the Presidents, 1789-1897, Volume 1 at 232, 467, Adams, Madison, Volume 2 at 625, Jackson, Volume 8 at 381, Cleveland. Pilker 158. In sum, the simplest and most obvious interpretation of the Constitution, if in itself sensible, is the most likely to be that meant by the people in its adoption. Lake County v. Rollins, 130 U.S. 662, 671. The most obvious and sensible reading of Section 3, supported by text and history, leads us to conclude that the presidency is an office under the United States, the president is an officer of the United States, and the presidential oath under Article 2 is an oath to support the Constitution. Pilker 159. President Trump asks us to hold that Section 3 disqualifies every oath-breaking insurrectionist except the most powerful one, and that it bars oath-breakers from virtually every office, both state and federal, except the highest one in the land. Both results are inconsistent with the plain language and history of Section 3. Pilker 160. We therefore reverse the District Court's finding that Section 3 does not apply to a president and conclude that Section 3 bars President Trump from 87. Holding the office of the president if its other provisions are met, namely, if President Trump engaged in insurrection. U.S. Const. Amend. 14. Section 3. Pilker 161. Before addressing the District Court's findings that President Trump engaged in insurrection, however, we consider President Trump's challenge to the admissibility of a congressional report on which the District Court premised some of its findings. F. The District Court did not err in admitting portions of the January 6 report. Pilker 162. President Trump asserts that the District Court wrongly admitted into evidence 31 findings from a congressional report drafted by the Select Committee to investigate the January 6 attack on the U.S. Capitol. The committee, which recounted the committee's investigation of the facts, circumstances, and causes of the attack on the Capitol. CHR Rep. Number 117 to 663, the report. In President Trump's view, the report is an untrustworthy, partisan political document and therefore constituted inadmissible hearsay under Rule 803(8)(c of the Colorado Rules of Evidence. We are unpersuaded. Under the deferential standard of review that governs, we perceive no error by the District Court in admitting portions of the report into evidence at trial. Pilker 163. We review a District Court's evidentiary rulings for an abuse of discretion. Zapata v. People, a court abuses its discretion. 88. Only if its decision is manifestly arbitrary, unreasonable, or unfair. Churchill v. University of Colorado, at Boulder, 2012 CO 54, Pilker 74, 285 p. 986, 1008. We may not consider whether we would have reached a different result, but only whether the trial court's decision fell within a range of reasonable options. Id. Pilker 164. Hearsay statements are out-of-court statements offered in court for the truth of the matter asserted. CRE 801c. Such statements are generally inadmissible, CRE 802, but CRE 803(8) creates an exception for reports of public offices or agencies, setting forth factual findings resulting from an investigation made pursuant to authority granted by law. This exception, however, applies only if the report is trustworthy. Id. Pilker 165. The federal rules of evidence, on which our evidentiary rules were modeled, contain a near identical exception to Colorado Rule 803(8), see Fed. R. Evid. 803(8), so we may look to federal case law interpreting the federal rule for guidance on how to assess trustworthiness, see Garcia v. Schneider Energy Serves. Incorporated, 2012 CO 62, Pilker 10, 287 p. 112, 115, noting that, Although we are not bound to interpret our rules, the same way the United States Supreme Court has interpreted its rules, we do look to the federal rules and federal decisions. 89. Interpreting those rules for guidance, Harding Glass Company v. Jones, 640 p. 1123, 1125 in. OSA law interpreting the federal rule is persuasive in analysis of the Colorado rule. Under federal law, courts are instructed to assume admissibility in the first instance. Beech Aircraft Corporation v. Rainey, 488 U.S. 153, 167. Thus, the party challenging the admissibility of a public or agency report bears the burden of demonstrating that the report is not trustworthy. Berry v. TRS, of International Asin, 467 F. Sup. 2D 91, 96. The federal courts have also identified 4 non-exclusive factors to help courts determine trustworthiness. 1. The timeliness of the investigation, the special skill or expertise of the investigating official, whether a hearing was held and the level at which it was conducted, and possible motivation problems. Id. At 97, see Beech Aircraft, 488 U.S. at 167 N. Pilker 166. The district court employed the foregoing presumption and 4 factors to analyze the report. The court determined that the first 3 Berry factors weigh strongly in favor of reliability. Anderson, Pilker 24. President Trump focuses his admissibility challenge on the 4th factor, possible motivation problems. Berry, 467 F. Sup. 2D at 97. Pilker 167. First, President Trump claims the report was biased against him because all 9 committee members voted in favor of impeaching him before their investigation began. Timothy Heaphy, chief investigative counsel for the committee, testified at trial, however, that although members certainly had hypotheses that were a starting point, such hypotheses did not impair the members' ability to be fair and impartial. Anderson, Pilker 26. The district court found Mr. Heaphy's testimony on this subject to be credible and that any perceived animus of the committee members towards Trump did not taint the conclusions of the January 6 report in such a way that would render them unreliable. Id. We see no abuse of discretion. See People v. Pitts, 13 p. 1218, 1221. It is the function of the trial court, and not the reviewing court, to weigh evidence and determine the credibility of the witnesses. Pilker 168. Second, President Trump believes that the political backdrop against which the report was created makes it unreliable. This argument proves too much. All is the first and best judge of whether tendered evidence meets th standard of trustworthiness and reliability. And E cannot say the trial court abused its discretion by refusing to admit the report. 91. Congressional reports contain some level of political motivation, yet neither CRE 838 nor the corresponding federal rule declares such reports per se inadmissible. Instead, as the district court explained, a court is at liberty to admit what it deems trustworthy. See Anderson, Pilker 28, c. For example, Berry, 467 F. Sup. 2D at 101, admitting report from a Senate investigation, Mariani v. United States, 80 F. Sup. 2D 352, 361, admitting minority report from a congressional investigation, Hobson v. Wilson, 556 F. Sup. 1157, 1183, admitting congressional committee report, Aft in part, Reverend in part, 737 F. 1. Pilker 169 3rd.
Just to say, yes, my optical mouse died, the battery went dead, and so I have to charge it up. Hence, I missed one of the footnotes to skip, but it wasn't so long. So please excuse. And now back to our regularly scheduled, well-written, as Scribby points out, direct, clear, and really convincing decision of the Colorado Supreme Court.
President Trump asserts that because Democrats outnumbered Republicans 7-2 on the committee, the report's findings are necessarily biased. The district court determined that although the report would have further reliability had there been greater Republican participation, that deficit did not demonstrate motivation problems. Anderson, Pilker 29:30. The district court observed that House Republicans opted to boycott the committee after then Speaker of the House Nancy Pelosi agreed to seat only 3 of the 5 Republicans recommended to her. Id. At Pilker 30. Despite then Speaker Pelosi's unprecedented move, the district court noted that the two Republicans who did sit were both duly elected Republicans. At Pilcrow 31, he investigative staff included many Republican lawyers. At Pilcrow 32, the staffing decisions did 92 not include any inquiry into political affiliation. And the overwhelming majority of witnesses were Trump administration officials and Republicans. At Pilcrow 33. The court reasoned that HASA facts all cut against interveners' argument that lack of participation of the minority party resulted in unreliable conclusions. At Pilcrow 34, Pilcrow 170 again, we perceive no abuse of discretion. CRE 803-8 assumes admissibility, Barry, 467 F sup, 2D at 96, and President Trump has not met his burden of demonstrating that, contrary to the evidence the district court highlighted, the report suffered from motivation problems. See id. Moreover, we remain mindful that this is a four-factor inquiry. No single factor is dispositive. Instead, any perceived shortcomings as to one must be weighed against the strengths of the others. Whatever the possible motivation problems, the weight of the other three factors remains. As the district court explained, passage of time does not impugn the report, as the investigation began 6 months after the attack and was completed in under 2 years. The investigative staff consisted of highly skilled lawyers, including 2 former U.S. attorneys, and there was a formal 10-day hearing in which 70 witnesses testified under oath. Anderson, Pilcrow 24. So, not only was the court's analysis of the fourth factor reasonable, but it also did not abuse its discretion in reaching its broader conclusion that the report was trustworthy. 93. Pilcrow 171. President Trump nonetheless argues that, even if the report is generally admissible under the CRE 803-8 exception, there were 11 admitted findings within the report that remained independently inadmissible. Even if the general admissibility of the report does not necessarily give a green light to multiple layers of hearsay, we conclude that only 2 of the 11 challenged findings constituted hearsay within hearsay 17, and even if there was error in admitting those findings, neither is of sufficient consequence to warrant reversal. See Liggett v. People, 135 p. 725, 733, explaining that, under harmless error review, we will reverse only if, viewing the evidence as a whole, the error substantially influenced the outcome or impaired the fairness of the trial, and that, 17 the 9
really long footnote. Skip.
In the context of a bench trial, the prejudicial effect of improperly admitted evidence is generally presumed innocuous. Pilcrow 172. First, the report cited a newspaper article stating that the election was called for President Biden. Although this is hearsay, the district court did not rely on the statement in its analysis, so President Trump was not prejudiced by any error in admitting this statement. See Rel v. People, 148 p. 126, 136. Here is no reasonable probability that Rail was prejudiced by the admission of the statements, thus, the trial court's error was harmless. Pilcrow 173. Second, the report explained that Chief of Staff Mark Meadows told White House counsel Pat Cipollone that President Trump doesn't want to do anything to stop the violence. HR Rep. Number 117-663, at 110. The fact that this statement is hearsay is irrelevant. The district court expressly noted that it has only considered those portions of the January 6 report which are referenced in this order and has considered no other portions in reaching its decision. Anderson, Pilcrow 38, and it did not mention this statement in its order, nor did it rely on it to reach any conclusions. Thus, President Trump's embedded hearsay argument is unavailing. Pilcrow 174. For these reasons, we conclude that the district court did not abuse its discretion by admitting portions of the report into evidence. Pilcrow 175. We now consider the district court's findings that President Trump engaged in an insurrection within the meaning of Section 395. G. President Trump engaged in insurrection. Pilcrow 176. President Trump challenges the district court's findings that he engaged in an insurrection. The Constitution leaves these terms undefined. Therefore, we must make a legal determination regarding what the drafters and ratifiers meant when they chose to deploy these words in Section 3. Mindful of the deferential standard of review afforded a district court's factual findings, we conclude that the district court did not clearly err in concluding that the events of January 6 constituted an insurrection and that President Trump engaged in that insurrection. 1. Standard of review. Pilcrow 177. As a general matter, we review findings of fact under either a clear error or abuse of discretion standard, and we review legal conclusions de novo. When, However, the issue before an appellate court presents a mixed question of law and fact. Colorado courts have taken different approaches, depending on the circumstances. For example, courts have sometimes treated the ultimate conclusion as one of fact and applied the clear error standard, id. In other cases, courts have concluded that a mixed question of law and fact mandates de novo review, id. And when a trial court made evidentiary findings of fact in 96, support of its application of a legal principle from another jurisdiction, we have found it appropriate to conduct an abuse of discretion review of the evidentiary factual findings supporting the legal conclusion and a de novo review of the legal conclusion itself, id. At 23. Pilcrel 178 for our purposes here, where we are called on to review the district court's construction of certain terms used in Section 3 to the facts established by the evidence, we will review the district court's factual findings for clear error and its legal conclusions de novo. 2. Insurrection, Pilcrel 179 dictionaries, both old and new, the district court's order, and the briefing by the parties and the amici curiae suggest several definitions of the word insurrection. Pilcrel 180 for example, Noah Webster's dictionary from 1860 defined insurrection as a rising against civil or political authority, the open and active opposition of a number of persons to the execution of law in a city or state. It is equivalent to sedition, except that sedition expresses a less extensive rising of citizens. It differs from rebellion, for the latter expresses a revolt, or an attempt to overthrow the government, to establish a different one, or to place the country under another jurisdiction. Noah Webster, An American Dictionary of the English Language 613, Accord John Bouvier, a law dictionary adapted to the Constitution and laws of 97, the United States of America and of the several states to the American Union. Pilcrel 181 Webster's Third New International Dictionary defines insurrection as an act or instance of revolting against civil or political authority or against an established government or an act or instance of rising up physically. Insurrection, Webster's Third New International Dictionary. Pilcrel 182 In light of these and other proffered definitions, the District Court concluded that an insurrection as used in Section 3 is a public use of force or threat of force by a group of people to hinder or prevent execution of the Constitution of the United States. Anderson, Pilcrow 240. Pilcrow 183 Finally, we note that at oral argument, President Trump's counsel, while not providing a specific definition, argued that an insurrection is more than a riot but less than a rebellion. We agree that an insurrection falls along a spectrum of related conduct. See the Brig Amy Warwick, The Prize Cases, 67 U.S., 2 Black, 635, 666. Insurrection against a government may or may not culminate in an organized rebellion, but a civil war always begins by insurrection against the lawful authority of the government. Case of Davis, 7 F. Cass, 63, 96, CCD, Virginia 98. 1871, No. 3,621a, although treason by levying war, in a case of civil war, may involve insurrection or rebellion, and they are usually its first stages, they do not necessarily reach to the actual levying of war. 77 CJS, Riot, Insurrection Section 36, Westlaw, insurrection is distinguished from rout, riot, and offenses connected with mob violence by the fact that, in insurrection, there is an organized and armed uprising against authority or operations of government, while crimes growing out of mob violence, however serious they may be and however numerous the participants, are simply unlawful acts and disturbance of the peace which do not threaten the stability of the government or the existence of political society. But we part company with him when he goes one step further. No authority supports the position taken by President Trump's counsel at oral argument that insurrectionary conduct must involve a particular length of time or geographic location. Pilcrel 184 Although we acknowledge that these definitions vary and some are arguably broader than others, for purposes of deciding this case, we need not adopt a single, all-encompassing definition of the word insurrection. Rather, it suffices for us to conclude that any definition of insurrection for purposes of Section 3 would encompass a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish a peaceful transfer of power in this country. 99. The required force or threat of force need not involve bloodshed, nor must the dimensions of the effort be so substantial as to ensure probable success. Moreover, although those involved must act in a concerted way, they need not be highly organized at the insurrection's inception. See Home Inns. Company of NYV. Davila, 212 F. 731, 736, T. Its inception an insurrection may be a pretty loosely organized affair. It may start as a sudden surprise attack upon the civil authorities of a community with incidental destruction of property by fire or pillage, even before the military forces of the constituted government have been alerted and mobilized into action to suppress the insurrection. Pilker 185. The question thus becomes whether the evidence before the district court sufficiently established that the events of January 6 constituted a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish the peaceful transfer of power in this country. We have little difficulty concluding that substantial evidence in the record supported each of these elements and that, as the district court found, the events of January 6 constituted an insurrection. Pilker 186. It is undisputed that a large group of people forcibly entered the Capitol and that this action was so formidable that the law enforcement officers on site could not control it. Moreover, contrary to President Trump's assertion that no evidence, 100, in the record showed that the mob was armed with deadly weapons or that it attacked law enforcement officers in a manner consistent with a violent insurrection, the district court found, and millions of people saw on live television, recordings of which were introduced into evidence in this case, that the mob was armed with a wide array of weapons. C. Anderson, Pilker 155. The court also found that many in the mob stole objects from the Capitol's premises or from law enforcement officers to use as weapons, including metal bars from the police barricades and officers' batons and riot shields, and that throughout the day, the mob repeatedly and violently assaulted police officers who were trying to defend the Capitol. Id. At Pilker 156:57, the fact that actual and threatened force was used that day cannot reasonably be denied. Pilker 187. Substantial evidence in the record further established that this use of force was concerted and public. As the district court found, with ample record support, the mob was coordinated and demonstrated a unity of purpose. They marched through the building chanting in a manner that made clear they were seeking to inflict violence against members of Congress and Vice President Pence. Id. At Pilker 243. And upon breaching the Capitol, the mob immediately pursued its intended target, the certification of the presidential election, and reached the House and Senate chambers within minutes of entering the building. Id. At Pilker 153. 101, Pilker 188. Finally, substantial evidence in the record showed that the mob's unified purpose was to hinder or prevent Congress from counting the electoral votes as required by the 12th Amendment and from certifying the 2020 presidential election, that is, to preclude Congress from taking the actions necessary to accomplish a peaceful transfer of power. As noted above, soon after breaching the Capitol, the mob reached the House and Senate chambers, where the certification process was ongoing. Id. This breach caused both the House and the Senate to adjourn, halting the electoral certification process. In addition, much of the mob's ire, which included threats of physical violence, was directed at Vice President Pence, who, in his role as President of the Senate, was constitutionally tasked with carrying out the electoral count. As discussed more fully below, these actions were the product of President Trump's conduct in singling out Vice President Pence for refusing President Trump's demand that the Vice President decline to carry out his constitutional duties. Anderson, Pilker 148, 170, 172:73, Pilker 189. In short, the record amply established that the events of January 6 constituted a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish the peaceful transfer of power in this country. Under any viable, 102, definition, this constituted an insurrection, and thus we will proceed to consider whether President Trump engaged in this insurrection. 3. Engaged in. Pilker 190. Dictionaries, historical evidence, and case law all shed light on the meaning of engaged in, as that phrase is used in Section 3. Pilker 191. Noah Webster's Dictionary from 1860 defined engage as to embark in an affair. Noah Webster, An American Dictionary of the English Language 696. Similarly, Webster's Third New International Dictionary defines engage as to begin and carry on an enterprise or to take part or participate. Engage, Webster's Third New International Dictionary, and Merriam-Webster defines engage as including both to induce to participate and to do or take part in something. Engage, Merriam-Webster Dictionary. Pilker 192. Attorney General Stanbury's opinions on the meaning of engage, which he issued at the time the 14th Amendment was being debated, are in accord with these historical and modern definitions. Attorney General Stanbury opined that a person may engage in insurrection or rebellion without having actually levied war or taken arms. Stanbury I, 12 Op. Atty General at 161. Thus, in Attorney General Stanbury's view, when individuals acting in their official capacities act in 103. The furtherance of the common unlawful purpose or do any overt act for the purpose of promoting the rebellion, they have engaged in insurrection or rebellion for Section 3 disqualification purposes. Id. At 161:62, See also Stanbury 2, 12 Op. Addy. General at 204, defining engaging in rebellion to require an overt and voluntary act, done with the intent of aiding or furthering the common unlawful purpose. Accordingly, disloyal sentiments, opinions, or sympathies would not disqualify, but when a person has, by speech or by writing, incited others to engage in rebellion, he must come under the disqualification. Stanbury 2, 12 Op. Addy. General at 205, Accord Stanbury I, 12 Op. Addy. General at 164, Pilcrow 193. Turning to case law construing the meaning of engaged in for purposes of Section 3, although we have found little precedent directly on point, cases concerning treason that had been decided by the time the 14th Amendment was ratified provide some insight into how the drafters of the 14th Amendment would have understood the term engaged in. For example, in Ex parte Ballman, 8 U.S. 75, 126, Chief Justice Marshall explained that if a body of men be actually assembled for the purpose of effecting by force a treasonable purpose, all those who perform any part, however minute, or however remote from the scene of action, and who are actually leagued in the general conspiracy, are to be considered as traitors. In other words, an individual need not directly 104. Participate in the overt act of levying war or insurrection for the law to hold him accountable as if he had. T is not necessary to prove that the individual accused was a direct, personal actor in the violence. If he was present, directing, aiding, abetting, counseling, or countenancing it, he is in law guilty of the forcible act, nor is even his personal presence indispensable, though he be absent at the time of its actual perpetration. Yet if he directed the act, devised or knowingly furnished the means, for carrying it into effect, instigating others to perform it, he shares their guilt. In treason there are no accessories. In recharge to grand jury treason, 30 F. Cass. 1047, 1048, Pilcrow 194. We find the foregoing definitions and authorities to be generally consistent, and we believe that the definition adopted and applied by the District Court is supported by the plain meaning of the term engaged in, as well as by the historical authorities discussed above. Accordingly, like the District Court, we conclude that engaged in requires an overt and voluntary act, done with the intent of aiding or furthering the common unlawful purpose. Anderson, Pilcrow 254, Pilcrow 195. In so concluding, we hasten to add that we do not read engaged in so broadly as to subsume mere silence in the face of insurrection or mere acquiescence therein, at least absent an affirmative duty to act. Rather, as Attorney General Stanbury observed, the force of the term to engage carries the idea of active rather than passive conduct, and of voluntary rather than compulsory action. Stanbury I, 12 Op. Addy. General at 161, see also Bode and Paulson, Supra, manuscript at 67, noting that passive acquiescence, resigned acceptance. 105. Silence, or inaction is not typically enough to have engaged in insurrection or rebellion. A person possesses an affirmative duty to speak or act. Pilcrow 196. The question remains whether the record supported the District Court's finding that President Trump engaged in the January 6 insurrection by acting overtly and voluntarily with the intent of aiding or furthering the insurrectionist common unlawful purpose. Again, mindful of our applicable standard of review, we conclude that it did, and we proceed to a necessarily detailed discussion of the evidence to show why this is so. Pilcrow 197. Substantial evidence in the record showed that even before the November 2020 general election, President Trump was laying the groundwork for a claim that the election was rigged. For example, at an August 17, 2020 campaign rally, he said that the only way we're going to lose this election is if the election is rigged. Anderson, Pilcrow 88. Moreover, when asked at a September 23, 2020 press briefing whether he would commit to a peaceful transfer of power after the election, President Trump refused to do so. Id. At Pilcrow 90. Pilcrow 198. President Trump then lost the election, and despite the facts that his advisors repeatedly advised him that there was no evidence of widespread voter fraud and that no evidence showed that he himself believed the election was wrought with fraud, President Trump ramped up his claims that the election was stolen from him and undertook efforts to prevent the certification of the election. 106. Results. For example, in a December 13, 2020 tweet, he stated, "Swing states that have found massive voter fraud, which is all of them, cannot legally certify these votes as complete and correct without committing a severely punishable crime." Id. At Pilcrow 101. And President Trump sought to overturn the election results by directly exerting pressure on Republican officeholders in various states. Id. At Pilcrow 103. Pilcrow 199. On this point, and relevant to President Trump's intent in this case, many of the state officials targeted by President Trump's efforts were subjected to a barrage of harassment and violent threats by his supporters. Id. At Pilcrow 104. President Trump was well aware of these threats, particularly after Georgia election official Gabriel Sterling issued a public warning to President Trump to stop inspiring people to commit potential acts of violence or one's going to get killed. President Trump responded by retweeting a video of Sterling's press conference with a message repeating the very rhetoric that Sterling warned would result in violence. At Pilcrow 105. Pilcrow 200 and President Trump continued to fan the flames of his supporters' ire, which he had ignited, with ongoing false assertions of election fraud, propelling the Stop the Steal movement and cross-country rallies leading up to January 6. At Pilcrow 106. Specifically, between Election Day 2020 and January 6, Stop the Steal organizers held dozens of rallies around the country, proliferating President 107. Trump's election disinformation and recruiting attendees, including members of violent extremist groups like the Proud Boys, the Oath Keepers, and the Three Percenters, QAnon conspiracy theorists, and white nationalists, to travel to Washington, D.C. on January 6. At Pilcrow 107. Pilcrow 201 Stop the Steal leaders also joined 2 million MAGA marches in Washington, D.C. on November 14, 2020, and December 12, 2020. At Pilcrow 108, again, as relevant to President Trump's intent here, after the November rally turned violent, President Trump acknowledged the violence but justified it as self-defense against Antifa scum. At Pilcrow 109. Pilcrow 202 With full knowledge of these sometimes violent events, President Trump sent the following tweet on December 19, 2020, urging his supporters to travel to Washington, D.C. on January 6, statistically impossible to have lost the 2020 election. Big protest in D.C. on January 6, be there, will be wild. At Pilcrow 112. Pilcrow 203 At this point, the record established that President Trump's plan was that when Congress met to certify the election results on January 6, Vice President Pence could reject the true electors who voted for President Biden and certify a slate of fake electors supporting President Trump, or he could return the slates to the states for further proceedings. At Pilcrow 113. Pilcrow 204 Far-right extremists and militias such as the Proud Boys, the Oath Keepers, and the Three Percenters viewed President Trump's December 19, 2020 tweet as a 108 call to arms, and they began to plot activities to disrupt the January 6 joint session of Congress. At Pilcrow 117. In the meantime, President Trump repeated his invitation to come to Washington, D.C. on January 6 at least 12 times. At Pilcrow 118. Pilcrow 205 On December 26, 2020, President Trump tweeted, "If a Democrat presidential candidate had an election rigged and stolen, with proof of such acts at a level never seen before, the Democrat senators would consider it an act of war, and fight to the death. Mitch and the Republicans do nothing, just want to let it pass, no fight." At Pilcrow 121. Pilcrow 206 And on January 1, 2021, President Trump retweeted a post from Kylie Jane Kramer, an organizer of the scheduled January 6 March for Trump, that stated, "The cavalry is coming, Mr. President." January 6, Washington, D.C. President Trump added to his retweet, "A great honor." At Pilcrow 119. Pilcrow 207 The foregoing evidence established that President Trump's messages were a call to his supporters to fight and that his supporters responded to that call. Further supporting such a conclusion was the fact that multiple federal agencies, including the Secret Service, identified significant threats of violence in the days leading up to January 6. At Pilcrow 123. These threats were made openly online, and they were widely reported in the press. Agency threat assessments thus stated, 109. That domestic violent extremists planned for violence on January 6, with weapons including firearms and enough ammunition to win a small war. Pilcrow 208 Along the same lines, the Federal Bureau of Investigation received many tips regarding the potential for violence on January 6. At Pilcrow 124, one tip said, "They think they will have a large enough group to march into D.C. armed and will outnumber the police so they can't be stopped. They believe that since the election was stolen it's their constitutional right to overtake the government, and during this COPE no U.S. laws apply. Their plan is to literally kill. Please take this tip seriously and investigate further." Pilcrow 209 The record reflects that President Trump had reason to know of the potential for violence on January 6. As president, he oversaw the agencies reporting the foregoing threats. At Pilcrow 123, in addition, Katrina Pearson, a senior advisor to both of President Trump's presidential campaigns, testified, on behalf of President Trump, that at a January 5, 2021 meeting, President Trump chose the speakers for the January 6 event at which he, 2, would speak, avoiding at least some extremist speakers, and that he knew that radical political extremists were going to be in Washington, D.C. on January 6 and would likely attend his speech. Ed. At Pilcrow 48, 126. Pilcrow 210 January 6 arrived, and in the early morning, President Trump tweeted, "If Vice President at Mike_Pence comes through for us, we will win the presidency." Many states want to decertify the mistake they made in certifying incorrect and even 110 fraudulent numbers in a process not approved by their state legislatures, which it must be. Mike can send it back. Id. At Pilcrow 127, he followed this tweet later that morning with another that said, "All Mike Pence has to do is send them back to the states, and we win." Do it, Mike, this is a time for extreme courage. Id. Pilcrow 211. These tweets had the obvious effect of putting a significant target on Vice President Pence's back, focusing President Trump supporters on the Vice President's role in overseeing the counting of the electoral votes and certifying the 2020 presidential election to ensure the peaceful transfer of power. Id. At Pilcrow 128, 291. Pilcrow 212. At about the same time, tens of thousands of President Trump supporters began gathering around the ellipse for his speech. Id. At Pilcrow 129. To enter the ellipse itself, attendees were required to pass through magnetometers. Id. At Pilcrow 130. Notably, from the approximately 28,000 attendees who passed through these security checkpoints, the Secret Service confiscated hundreds of weapons and other prohibited items, including knives or blades, pepper spray, brass knuckles, tasers, body armor, gas masks, and batons or blunt instruments. Id. At Pilcrow 130:31. Approximately 25,000 additional attendees remained outside the Secret Service perimeter, thus avoiding the magnetometers. Id. At Pilcrow 132, Pilcrow 213. President Trump then gave a speech in which he literally exhorted his supporters to fight at the Capitol. Among other things, he told the crowd, 111. "We're gathered together in the heart of our nation's capital for one very, very basic reason, to save our democracy." Id. At Pilcrow 135, Republicans are constantly fighting like a boxer with his hands tied behind his back. It's like a boxer, and we want to be so nice, we want to be so respectful of everybody, including bad people, and we're going to have to fight much harder. Id. Now, it is up to Congress to confront this egregious assault on our democracy, and after this, we're going to walk down, and I'll be there with you. Id. We're going to walk down to the Capitol, and we're going to cheer on our brave senators and congressmen and women, and we're probably not going to be cheering so much for some of them, because you'll never take back our country with weakness. You have to show strength and you have to be strong. Id. When you catch somebody in a fraud, you're allowed to go by very different rules. Id. This the most corrupt election in the history, maybe of the world. This is not just a matter of domestic politics, this is a matter of national security. Id. And we fight like hell, and if you don't fight like hell, you're not going to have a country anymore. Id. Pilcrow 214. Unsurprisingly, the crowd at the ellipse reacted to President Trump's words, with calls for violence. Indeed, after President Trump instructed his supporters to march to the Capitol, members of the crowd shouted, "Storm the Capitol, invade the Capitol building, and ache the Capitol." Id. At Pilcrow 141, and? Before he had even concluded his speech, President Trump's supporters followed his instructions. Id. At Pilcrow 146. The crowd marched to the Capitol, many carrying 112 Revolutionary War flags and Confederate battle flags, quickly breached the building, and immediately advanced to the House and Senate chambers to carry out their mission of blocking the certification of the 2020 presidential election. Pilcrow 215. By 1:21 p.m., President Trump was informed that the Capitol was under attack. Id. At Pilcrow 169. Rather than taking action to end the siege, however, approximately 1 hour later, at 2:24 p.m., he tweeted, "Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent or inaccurate ones which they were asked to previously certify. USA demands the truth." Id. At Pilcrow 170. Pilcrow 216. This tweet was read over a bullhorn to the crowd at the Capitol, and produced further violence, necessitating the evacuation of Vice President Pence from his Senate office to a more secure location to ensure his physical safety. Id. At Pilcrow 171:75. Pilcrow 217. President Trump's next public communications were two tweets sent at 2:38 p.m. and 3:13 p.m., encouraging the mob to remain peaceful and to stay peaceful. Obviously, The mob was not at all peaceful, but neither tweet condemned the violence nor asked the mob to disperse. Ed. At Pilcrow 178, alteration in original, 113. Pilcrow 218. Throughout these several hours, President Trump ignored pleas to intervene and instead called on senators, urging them to help delay the electoral count, which is what the mob, upon President Trump's exhortations, was also trying to achieve. Ed. At Pilcrow 180. And President Trump took no action to put an end to the violence. To the contrary, as mentioned above, when told that the mob was chanting, "Hang Mike Pence," President Trump responded that perhaps the vice president deserved to be hanged. Ed. President Trump also rejected pleas from House Republican leader Kevin McCarthy, imploring him to tell his supporters to leave the Capitol, stating, "Well, Kevin, I guess these people are more upset about the election than you are." Ed. Pilcrow 219. Finally, at 4:17 p.m., President Trump released a video urging the mob to go home now. Ed. At Pilcrow 186. Even then, he did not condemn the mob's actions. Ed. At Pilcrow 187. Instead, he sympathized with those who had violently overtaken the Capitol, telling them that he knew their pain. Ed. At Pilcrow 186:87. He told them that he loved them and that they were very special. Ed. At Pilcrow 186. And he repeated his false claim that the election had been stolen notwithstanding his landslide victory, thereby further endorsing the mob's effort to try to stop the peaceful transfer of power. Ed. At Pilcrow 186:87. Pilcrow 220. A short while later, President Trump reiterated this supportive message to the mob by justifying its actions, tweeting at 6:01 p.m., "These are the things and 114 events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from great patriots who have been badly and unfairly treated for so long. Go home with love and in peace." Ed. At Pilcrow 189, President Trump concluded by encouraging the country to remember this day forever. Ed. Pilcrow 221. We conclude that the foregoing evidence, the great bulk of which was undisputed at trial, established that President Trump engaged in insurrection. President Trump's direct and express efforts, over several months, exhorting his supporters to march to the Capitol to prevent what he falsely characterized as an alleged fraud on the people of this country, were indisputably overt and voluntary. Moreover, the evidence amply showed that President Trump undertook all these actions to aid and further a common unlawful purpose that he himself conceived and set in motion: prevent Congress from certifying the 2020 presidential election and stop the peaceful transfer of power. Pilcrow 222. We disagree with President Trump's contentions that the record does not support a finding that he engaged in an insurrection, because engaged does not include incite, and he did not have the requisite intent to aid or further the insurrectionist's common unlawful purpose. Pilcrow 223. As our detailed recitation of the evidence shows, President Trump did not merely incite the insurrection, even when the siege on the Capitol was fully 115 underway, he continued to support it by repeatedly demanding that Vice President Pence refuse to perform his constitutional duty and by calling senators to persuade them to stop the counting of electoral votes. These actions constituted overt, voluntary, and direct participation in the insurrection. Pilcrow 224. Moreover, the record amply demonstrates that President Trump fully intended to, and did, aid or further the insurrectionists' common unlawful purpose of preventing the peaceful transfer of power in this country. He exhorted them to fight to prevent the certification of the 2020 presidential election. He personally took action to try to stop the certification, and for many hours, he and his supporters succeeded in halting that process. Pilcrow 225. For these reasons, we conclude that the record fully supports the district court's finding that President Trump engaged in insurrection within the meaning of Section 3H. President Trump's speech on January 6 was not protected by the First Amendment right to freedom of speech. Pilcrow 226. President Trump contends that his speech on January 6 was protected by the First Amendment and, therefore, cannot be used to justify his disqualification from office under Section 3. The district court concluded that this speech was unprotected by the First Amendment. Anderson, Pilcrow 298. We agree with the district court. 116. 1. Standard of review. Pilcrow 227. In considering President Trump's First Amendment challenge, we undertake an independent review of the record, to be sure that the speech in question actually falls within unprotected category of communication. Bose Corporation v. Consumers Union of U.S. Incorporated, 466 U.S. 485, 505. We have interpreted this independent review as being akin to de novo review. Bose recognizes, however, that we may give some presumption of correctness to factual findings, 466 U.S. at 500, especially those that do not involve the application of standards of law, id. at 500 n. Or those that arise from complex cases such as this one, where the district judge has lived with the controversy, id. at 500. Focusing on the findings by the district court, we therefore examine for ourselves the statements in issue and the circumstances under which they were made to see, whether they are of a character which the principles of the First Amendment protect, id. at 508, first alteration in original, quoting Pennekamp v. Florida, 328 U.S. 331, 335. 2. First Amendment protections and incitement. Pilcrow 228. The First Amendment to the U.S. Constitution provides that Congress shall make no law, abridging the freedom of speech. U.S. Const. Amend. I. This. 117. Robust protection for speech functions to invite dispute, terming Yellow v. Chicago, 337 U.S. 1, 4, and was fashioned to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people. Pilcrow 229. Even so, the right of free speech is not absolute at all times and under all circumstances. Chaplinsky v. New Hampshire, 315 U.S. 568, 571. The First Amendment does not protect, for example, true threats. Watts v. United States, 394 U.S. 705, 708. Speech essential to criminal conduct. Packingham v. North Carolina, 582 U.S. 98, 107, or speech that incites lawless action. Brandenburg v. Ohio, 395 U.S. 444, 447. It is this last strand of First Amendment jurisprudence that the parties debate here. Pilcrow 230. As the Supreme Court explained in Brandenburg, the First Amendment's constitutional guarantees of free speech do not permit a state to forbid or prescribe advocacy of the use of force or of law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. 395 U.S. at 447. Under Brandenburg and its progeny, the modern test to determine whether speech is unprotected under the First Amendment because it incited lawless action is whether the speech explicitly or implicitly encouraged the use of violence or lawless action. The 118. Speaker intended that the speech would result in the use of violence or lawless action, and the imminent use of violence or lawless action was the likely result of the speech. Neumann, Pilcrow 231. President Trump contends that the district court.
Sorry, I got a little overexcited trying to skip there, and it moved as I was hitting click. So we're going to start over with 3, applying the Brandenburg test.
3. Applying the Brandenburg test. A. Context. Pilcrow 231. President Trump contends that the district court erred by examining the broader context in which President Trump's speech was made, thereby expand the context relevant to a Brandenburg analysis beyond anything recognized in precedent. He asserts that we should examine his speech only in the narrow context in which it was made. We disagree. Pilcrow 232. In Schenck v. United States, 249 U.S. 47, 52, the Supreme Court addressed, for the first time, advocacy of illegal conduct, and it recognized the
Pause for the long footnote. The
importance of context in holding that the character of every act depends upon the circumstances in which it is done. Although the Supreme Court has said little about how to analyze incitement since Brandenburg, it offered some guidance regarding a court's use of other statements for context in NAACP v. Claiborne Hardware Company, 458 U.S. 886, Pilcrow 233. In Claiborne Hardware, the court considered speeches given by Charles Evers, the field secretary of the Mississippi NAACP, in connection with the NAACP's boycott of white merchants in Claiborne County from 1966 to 1969, 458 U.S. at 890. Evers declared to black residents of Claiborne County that blacks who traded with white merchants would be answerable to him, and that any Uncle Toms who broke the boycott would have their necks broken by their own people. Id. at 900 n. Evers' statements also included that boycott violators would be disciplined by their own people, and he warned that the sheriff could not sleep with boycott violators at night. Id. at 902. The court held that Evers' speeches were protected by the First Amendment but said that after other evidence of authorization of wrongful conduct, the references to discipline in the speeches could be used to corroborate that evidence. Id. at 929. By considering and placing value in the absence of corroborating evidence of Evers' violent intentions, the court implied that courts may look to circumstances beyond the speech itself to determine intent. See United States v. White, 610 F. 120, 956, 961 /62, relying on Claiborne hardware in denying a motion to dismiss in a solicitation case based on the existence of further evidence of the relationship between and his followers, which will show the posting was a specific request to followers. Pilcrow 234. While incitement precedent is sparse, the case law on true threats is instructive regarding the importance of context. True threats and incitement are doctrinally distinct, but true threats are the closest cousin to incitement under the First Amendment. Counterman v. Colorado, 600 U.S. 66, 97, Sotomayor, J., concurring in part, Accord United States v. Howell, 719 F. 1258, 1260, the line between the two forms of speech may be difficult to draw in some instances. See also G. Robert Blakey and Brian J. Murray, Threats, Free Speech, and the Jurisprudence of the Federal Criminal Law, 2002 BYU L. Rev. 829, 1069, explaining that both exceptions involve exhortations regarding violence that derive from Schenck's clear and present danger test.
And pausing for the footnote, and moving on to the next page.
Pilcrow 235 and multiple federal circuit courts conducting a true threat analysis confirm what common sense suggests. When assessing whether someone means to threaten another with unlawful violence, we sometimes need to consider more than the behavior exhibited on one occasion. Of Life Activists, 290 F. 1058, 1078, rejecting an argument that context means the direct circumstances surrounding delivery of the threat, and instead concluding that and so far as we can tell, other circuits as well, consider the whole factual context and all of the circumstances in order to determine whether a statement is a true threat. Internal citation omitted, overruled on other grounds by Planned Parenthood, 290 F. At 1066-77, and United States v. Hanna, 293 F. 1080, 1088 N, United States v. Hart, 212 F. 1067, 1071, considering whether the maker of the threat had made similar statements to the victim on other occasions and whether the victim had reason to believe that the maker of the threat had a propensity to engage in violence when determining whether a true threat exists. So too with incitement, context matters. Pilcrow 236. This is not to say, as President Trump contends the district court found, that we may consider any speech ever uttered by in evaluating incitement. Of course, there are limits, but we need not define those outer limits. 122. Now, instead, we simply conclude that it was appropriate for the district court to consider President Trump's history of courting extremists and endorsing political violence as legitimate and proper, as well as his efforts to undermine the legitimacy of the 2020 election results and hinder the certification of the Electoral College results in Congress. Anderson, Pilcrow 289, Pilcrow 237. With this in mind, we review the district court's application of Brandenburg's three-prong test. B. Encouraging the use of violence or lawless action. Pilcrow 238. Again, the first prong of the test for incitement is that the speech explicitly or implicitly encourage the use of violence or lawless action. Nguyenema, 903 F. At 609, Pilcrow 239. The district court made dozens of findings regarding the general atmosphere of political violence that President Trump created before January 6, many of which we have already outlined in discussing why the district court concluded that President Trump engaged in insurrection. We incorporate those observations here by reference and supplement them with other illuminating evidence from the record below. For example, the district court found that February 2016 rally, Trump told his supporters that in the old days, a protester would be carried out on a stretcher and that he would like to punch him in the face. Anderson, Pilcrow 68. In March 2016, President Trump, 123, responded to questions about his supporters' violence by saying it was very, very appropriate and we need a little bit more of it. At Pilcrow 69. And during the 2020 election cycle, President Trump threatened to deploy the military to Minneapolis to shoot looters amid protest over the police killing of George Floyd. At Pilcrow 76, and told the Proud Boys to stand back and stand by during a debate for the 2020 presidential election. At Pilcrow 77, Pilcrow 240. The district court also credited the testimony of Professor Peter Simi, a professor of sociology at Chapman University, whom it had qualified as an expert in political extremism, including how extremists communicate, and how the events leading up to and including the January 6 attack relate to long-standing patterns of behavior and communication by political extremists. At Pilcrow 42. He testified, according to the court's summary, that violent far-right extremists understood that Trump's calls to fight, which most politicians would mean only symbolically, were, when spoken by Trump, literal calls to violence by these groups, while Trump's statements negating that sentiment were insincere and existed to obfuscate and create plausible deniability, id. at Pilcrow 84, and that Trump's speech took place in the context of a pattern of Trump's knowing encouragement and promotion of violence to develop and deploy a shared coded language with his violent supporters, id. at Pilcrow 142. 124. Pilcrow 241. As we described in the foregoing section, the District Court further found that President Trump encouraged and supported violence before and after the 2020 election by telling his supporters that the only way we're going to lose this election is if the election is rigged. Remember that, id. at Pilcrow 88, that the election was a fraud on the American public, id. at Pilcrow 92, see also id. at Pilcrow 101, swing states that have found massive voter fraud, which is all of them, cannot legally certify these votes as complete and correct without committing a severely punishable crime, and that the Democrats had stolen an election that rightfully belonged to President Trump and his supporters, id. at Pilcrow 93, 96. The District Court also found that any of the state officials targeted by Trump's campaign of intimidation were subject to a barrage of harassment and violent threats by supporters, prompting Georgia election official Gabriel Sterling to issue a public warning to Trump to stop inspiring people to commit potential acts of violence or someone's going to get killed. Id. at Pilcrow 104, last alteration in original, see also id. at Pilcrow 105, finding that our right extremists understood Trump's refusal to condemn the violence as an endorsement of the use of violence to prevent the transfer of presidential power. Pilcrow 242. The District Court then identified specific incendiary language in President Trump's speech at the Ellipse on January 6, some of which we alluded to earlier in 125. This opinion, to reiterate, President Trump announced, "We're going to walk down, and I'll be with you, we're going to walk down, to the Capitol," id. at Pilcrow 135. He used the word fight or variations of it times during his Ellipse speech, id. at Pilcrow 137, see also, for example, id. at Pilcrow 135, and we fight like hell, and if you don't fight like hell, you're not going to have a country anymore. He declared, "Can you catch somebody in a fraud," a sentiment he had repeatedly said had occurred with the 2020 election. "You're allowed to go by very different rules," id. at Pilcrow 135, see also id. at Pilcrow 138, "You don't concede when there's theft involved," and he claimed that our election victory stolen by emboldened radical left Democrats, id. at Pilcrow 135. Pilcrow 243. In short, the District Court found that President Trump's speech at the Ellipse was understood by a portion of the crowd as a call to arms, id. at Pilcrow 145. And the District Court here is not the first or only court to reach this conclusion. In Thompson v. Trump, 590 F. Sup. 3D 46, 118, the U.S. District Court for the District of Columbia found that President Trump invited his supporters to Washington, D.C., after telling them for months that corrupt and spineless politicians were to blame for stealing an election from them, retold that narrative when thousands of them assembled on the Ellipse, and directed them to march on the Capitol building, where those very politicians were at work to certify an election that he had lost. 126. The court concluded that President Trump's speech was, therefore plausibly, a positive instigation of a mischievous act. 20 id. Our independent review of the record in this case brings us to the same conclusion. President Trump incited and encouraged the use of violence and lawless action to disrupt the peaceful transfer of power. The tenor of President Trump's messages to his supporters in exhorting them to travel to Washington, D.C. on January 6 was obvious and unmistakable. The allegedly rigged election was an act of war, and those victimized by it had an obligation to fight back and to fight aggressively. And President Trump's supporters did not miss or misunderstand the message. The cavalry was coming to fight. Pilcrow 244. The fact that, at one point during his speech, President Trump said that everyone here will soon be marching to the Capitol building to peacefully and patriotically make your voices heard does not persuade us that the District Court erred in finding that the first prong of the Brandenburg test was met. See Thompson, 590 F. Sup. 3D at 113:14. This isolated reference cannot inoculate.
Okay, we're going to pause it there to skip the footnote. I'm also going to take this opportunity to see, brackets. I thought I unchecked brackets last time, but it was braces, which apparently is different. So hopefully we'll pick up some of these bracketed phrases like Trump in this sentence. Also, to let you know, the next time that it makes sense to take a break, I will pause. I'm getting hungry. So I'm going to take a 5-minute break to heat up some food. At least bring it back in here to be able to eat it with my mic muted. but that is, it's going to be right after this paragraph. So get ready to take a break. Trump.
Trump, against the
it
conclusion
works.
that his exhortation, made nearly an hour later, to fight like hell immediately before sending rally-goers to the Capitol, within the context of the larger speech and circumstances, was not protected expression. Ed. At 117.
All right, and with that, we've been going for an hour and 5 minutes, which usually, because I waffle for the first 5 minutes, means that we've whacked out a good 60 minutes. Looks like there's like an hour and a half left to go. I'm kind of hoping, like at the bottom of an article, that there's like references for 40 pages, so we don't have to go for another that length. But we'll see how long. I'm feeling pretty good, but I do need some energy. So let's all take a break. Get up, walk around, stretch your legs, give yourself a bit of a chance to move a bit, get some hydration at you, get some water, and yeah, we will come back here. It is currently 17:07, bum o'clock. So let's all come back by 17:12. You can come back later, but that's when I will be back. And I'm going to see what I can do about this flickering. It's an OBS problem I've learned, not a camera problem. Thought I fixed it, but I didn't. And I'm always fiddling with things. All right, let's get back to the pre-show and the pre-show music. Where's my jazz? Where's my smooth jazz? Oh, there it is. Oh, but it's muted. All right. I'll get you some jazz, and then we'll go ahead and transition between the frames and start the break. Bye-bye. right, and we're back. So I hope everyone was able to enjoy our break. And now we're going to continue on again with this incredibly direct and well-written production. It's a decision by the Colorado Supreme Court. Okay.
C. Intent to produce violent or lawless action. Pilcrow 245. The second prong of the test for incitement is that the speaker intends that his speech will result in the use of violence or lawless action. Nguyenema, 903f. At 609, the Supreme Court has interpreted this second prong of the Brandenburg test to require specific intent. Counterman, 600 U.S. at 79, 81, establishing that when incitement is at issue, we have spoken in terms of specific intent, presumably equivalent to purpose or knowledge, and defining acting purposely as consciously deserting a result. So, we must consider whether President Trump's exhortations at the ellipse on January 6 to fight like hell, and his 21. There is some uncertainty as to whether specific intent to incite imminent.
Sorry, I'm using my mouse on a bedspread and it's not the most accurate. So sometimes I'm slightly delayed because I can't get the perfect thing. Skipping that footnote and January 6th to fight like hell and his
urgings that his followers go to the Capitol and that they would get to go by very different rules, were intended to produce imminent lawless action. Pilcrow 246. The District Court concluded that President Trump exhibited the requisite intent here. It found that, before the January 6 rally, President Trump knew that his supporters were angry and prepared to use violence to stop the steal, including physically preventing Vice President Pence from certifying the election. Anderson, Pilcrow 128, and that President Trump's response to the events following his speech support that President Trump endorsed and intended the actions of the mob on January 6, id. At Pilcrow 193, second alteration in original. Based on these findings of fact, the court concluded that President Trump acted with the specific intent to incite political violence and directed at the Capitol with the purpose of disrupting the electoral certification. Id. At Pilcrow 293. Pilcrow 247. The District Court found that President Trump knew, before he gave his speech, that there was the potential for violence on January 6. It found that President Trump himself agrees that his supporters listened to him, like no one else. Id. At Pilcrow 63, second alteration in original, and that federal agencies that President Trump oversaw identified threats of violence ahead of January 6, including threats to storm the U.S. Capitol and kill elected officials. Id. At Pilcrow 123:24, 129. Pilcrow 248. The court also found that President Trump's conduct and tweets, which we outlined above, from the time he was told of the attack on the Capitol at 1:21 p.m. until Congress reconvened later that night, indicated his intent to produce lawless or violent conduct. See id. At Pilcrow 169:73, 178, 183, 186, 189. Pilcrow 249. In conducting our independent review of the District Court's factual findings, we agree that President Trump intended that his speech would result in the use of violence or lawless action on January 6 to prevent the peaceful transfer of power. Despite his knowledge of the anger that he had instigated, his calls to arms, his awareness of the threats of violence that had been made leading up to January 6, and the obvious fact that many in the crowd were angry and armed, President Trump told his riled-up supporters to walk down to the Capitol and fight. He then stood back and let the fighting happen, despite having the ability and authority to stop it, with his words or by calling in the military, thereby confirming that this violence was what he intended. Pilcrow 250. We therefore conclude that the second prong of the Brandenburg test has also been met. D. Likely to incite or produce imminent lawless action. Pilcrow 251. Finally, for speech to be unprotected, we must conclude that the imminent use of violence or lawless action is the likely result of the speech. Nguyenema, 903f. At 609, 130. Pilcrow 252. The District Court found that Professor Simi reviewed President Trump's relationship with his supporters over the years, identified a pattern of calls for violence that his supporters responded to, and explained how that long experience allowed President Trump to know how his supporters responded to his calls for violence using a shared language that allowed him to maintain plausible deniability with the wider public. Ed. At Pilcrow 62. Pilcrow 253. Professor Simi then testified about examples of these patterns of canned response that President Trump developed and used to incite violence by his supporters. Id. At Pilcrow 64. In one such instance, a November 2015 political rally, President Trump told his supporters to get a protester the hell out of here, and the protester was then assaulted, When asked about the attack the next day, Trump said maybe, the protester, should have been roughed up. Id. At Pilcrow 66, third and fourth alterations in original. Pilcrow 254 further, the district court found that on January 1, 2021, President Trump retweeted a post from Kylie Jane Kramer, an organizer of March for Trump on January 6, saying, "The cavalry, sick, is coming, Mr. President." Id. At Pilcrow 119, it found that, according to Professor Simi, President Trump's December 19, 2020, "will be wild" tweet had an immediate effect on far-right extremists and militias, who viewed the tweet as a call to arms and began to plot activities to disrupt the January 6, 2021 joint session. Id. At Pilcrow 117, 131. Pilcrow 255. These findings support the conclusion that President Trump's calls for imminent lawlessness and violence during his speech were likely to incite such imminent lawlessness and violence. When President Trump told his supporters that they were allowed to go by very different rules and that if they did not fight like hell, they would not have a country anymore, it was likely that his supporters would heed his encouragement and act violently. We therefore hold that this final prong of the Brandenburg test has been met. Pilcrow 256. In sum, we conclude that President Trump's speech on January 6 was not protected by the First Amendment. 4. Conclusion. Pilcrow 257. The District Court erred by concluding that Section 3 does not apply to the President. We therefore reverse the District Court's judgment. As stated above, however, we affirm much of the District Court's reasoning on other issues. Accordingly, we conclude that because President Trump is disqualified from holding the office of President under Section 3, it would be a wrongful act under the Election Code for the Secretary to list President Trump as a candidate on the presidential primary ballot. Therefore, the Secretary may not list President Trump's name on the 2024 presidential primary ballot, nor may she count any write-in votes cast for him. See Section 17114(2), CRS. A vote for a write-in candidate shall not be counted unless that candidate is qualified to hold the office. 132. For which the elector's vote was cast, but we stay our ruling until January 4, 2024, the day before the Secretary's deadline to certify the content of the presidential primary ballot. If review is sought in the Supreme Court before the stay expires, it shall remain in place, and the Secretary will continue to be required to include President Trump's name on the 2024 presidential primary ballot until the receipt of any order or mandate from the Supreme Court. Chief Justice Boatwright dissented. Justice Sammer dissented. Justice Birkenkotter dissented. 133. Chief Justice Boatwright dissenting.
Okay, well, I guess the question is if we want to go on with the dissents, and I think in fairness we should. So, in conclusion, again, I am not a legal expert by any stretch of the imagination. Excuse me, I was eating my delicious Christmas curry, and it's a little warm, so I'm starting to feel the effects of the heat on my face. It's like bam, 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 bam. It's all laid out really well and clear, and it's incredibly convincing. I mean, I haven't read that many legal decisions, but all of this seems grounded in evidence and case law in a way that would be required. So it's gonna be interesting to see what the Supreme Court does with this. On the dissenting, I understand from watching analysis on the news that this section tends to focus more on Colorado law than constitutional issues. So I think that you can kind of be prepared for that. I don't know if we need to read all of the individual dissents. We'll see how it goes, because we've got, I guess it's an hour and 20 minutes left. Let's go and see how it goes along. I think as long as we're here, and this is much more chilled than to try to catch everything like I was trying to do yesterday. So if y'all don't mind, yeah, let's just keep going. Let's roll with this, and I'm gonna keep eating my curry.
Pilcrow 258. I agree with the majority that an action brought under Section 11113, CRS of Colorado's Election Code, may examine whether a candidate is qualified for office under the U.S. Constitution, but Section 11113 has a limited scope. Kuhn v. Williams, 2018 CO 30M, Pilcrow 1N. 418 p. 478, 480 n. Per curiam, unanimous, emphasizing the narrow nature of our review under Section 11113. In my view, the claim at issue in this case exceeds that scope. The voters, the electors, action to disqualify former President Donald J. Trump under Section 3 of the 14th Amendment present uniquely complex questions that exceed the adjudicative competence of Section 11113's expedited procedures. Simply put, Section 11113 was not enacted to decide whether a candidate engaged in insurrection. In my view, this cause of action should have been dismissed. Accordingly, I respectfully dissent. The elector's challenge is incompatible with a Section 11113 proceeding. Pilcrow 259 Section 11113 provides for the resolution of potential election code violations in a timely manner. In many scenarios, Colorado voters can challenge the Secretary of State's, the Secretary, certification of a candidate's qualifications. Carson v. Reiner, 2016 CO 38, Pilcrow 17, 370 p. 1137, 1141, acknowledging that Section 11113 clearly comprehends challenges to a broad range of wrongful acts committed by Colorado's election officials charged with 1. Duties under the code, and comprehends a specific challenge to a designated election official's certification of a candidate, while Section 11113 only offers voters a narrow opportunity. Kuhn, Pilcrow 28, 418 p. At 484, that opportunity has proven effective as voters have compelled the Secretary to omit from the ballot unqualified candidates whom they would have otherwise listed. For example, at Pilcrow 57, 418 p. At 489, barring a candidate from the ballot because his petition circulator was not a Colorado resident. Section 11113's grant of discretionary review to this court has also vindicated voters' rights by preventing a decision that would have compelled the Secretary to place an unqualified candidate on the ballot. Griswold v. Ferrigno Warren, 2020 CO 34, Pilcrow 26, 462 p. 1081, 1087, barring a candidate from the ballot because she failed to gather sufficient signatures. Pilcrow 260 further, our election code suggests that a petitioner may base a challenge to the Secretary's certification of an aspiring presidential primary candidate on federal law. Compare Section January 4, 12032A, CRS, stating that a candidate must be qualified, with Section 1412001, CRS, declaring that the code conforms to federal law. See also Codes v. Dish Network, LLC, 2015 CO 44, Pilcrow 20, 350 p. 849, 853, relying on federal law to interpret lawful activity in a Colorado statute. We have previously held, however, that some federal law claims cannot be adjudicated under Section 11113. For example, Frazier v. Williams, 2017 CO 85, Pilcrow 19. 2. 401 p. 541, 545, concluding that a 42 U.S.C. Section 1983 claim cannot be the basis of, or joined to, a Section 11113 action. Pilcrow 261. But not all federal questions exceed the scope of Section 11113. A qualification challenge under Article 2, Section 11 or the 22nd Amendment lends itself to Section 11113's procedures. Although a claim that a candidate is not 35 years old may be easier to resolve than a claim that a candidate is not a natural-born citizen, these presidential qualifications are characteristically objective, discernible facts. Age, time previously served as president, and place of birth all parallel core qualification issues under Colorado's election code. Conversely, all these questions pale in comparison to the complexity of an action to disqualify a candidate for engaging in insurrection.
All right, I'm going to skip the footnote as I have in the past. I'm not convinced, considering that they actually handled the complexity of a disqualification of a candidate. So to say that they can't do it after they clearly just did seems unconvincing to me.
Pilcrow 262. Far from presenting a straightforward biographical question, Section 3 of the 14th Amendment prescribes insurrectionist U.S. officers from again holding office. U.S. Const. Amend. 14. Section 3. Unlike qualifications such as age and place of birth, an application of Section 3 requires courts to define complex terms, determine legislative intent from over 150 years ago, and make factual findings foreign to our election code. The electors contend that there is nothing particularly unusual about a Section 11113 proceeding raising constitutional issues. However, The framework that Section 11113 offers for identifying qualified candidates is not commensurate with the extraordinary determination to disqualify a candidate because they engaged in insurrection against the Constitution. See Dis. Op. Pilcrow 352, Birkencotter, J., dissenting, noting that the historical application of Section 11113 has been limited to challenges involving relatively straightforward issues, like whether a candidate meets a residency requirement for a school board election. Recognizing this limitation of Section 11113 is not novel. See Kuhn, Pilcrow 1N. 418p. At 480n. Emphasizing the narrow nature of our review under Section 11113 and declining to address a First Amendment challenge to Colorado's residency requirement for petition.
I'm going to again skip the footnote, continued from above, I believe, and I'm still just not convinced by this at all. Oh no, we can establish easy facts, but when a fact is hard, we can't establish it. The majority did a pretty darn good job using definitions and precedent, so...
Circulators because such claims exceed this court's jurisdiction in a Section 11113 action. Pilcrow 263 dismissal is particularly appropriate here because the electors brought their challenge without a determination from a proceeding, for example, a prosecution for an insurrection-related offense, with more rigorous procedures to ensure adequate due process. Instead, the electors relied on Section 11113 and its breakneck pace to declare President Trump a disqualified insurrectionist. See Frazier, Pilcrow 11, 401p. At 544. 2. As demonstrated by the proceeding below, the statutory timeline for a Section 11113 proceeding does not permit a claim as complex as the electors. Pilcrow 264. In addition to qualitative incompatibilities, the complexity of the electors' claims cannot be squared with Section 11113 as truncated timeline for adjudication. Section 11113 actions for presidential primary ballots fulfill a need for speed by requiring the district court to hold a hearing within 5 days and issue its decision within 48 hours of the hearing. Any such challenge must provide notice in a summary manner of an alleged impropriety that gives rise to the complaint. No later than 5 days after the challenge is filed, a hearing must be held at which time the district court shall hear the challenge and assess the validity of all alleged improprieties. The district court shall issue findings of fact and conclusions of law no later than 48 hours after the hearing. The party filing the challenge has the burden to sustain the challenge by a preponderance of the evidence. 5. Section January 4, 1204, CRS. This speed comes with consequences, namely, the absence of procedures that courts, litigants, and the public would expect for complex constitutional litigation. As President Trump argues and the electors do not contest, Section 11113 as procedures do not provide common tools for complex fact-finding, preliminary evidentiary or pretrial motions hearings, subpoena powers, basic discovery, depositions, and time for disclosure of witnesses and exhibits. This same concern was raised in Frazier. The then Secretary argued that it is impossible to fully litigate a complex constitutional issue within days or weeks, as is typical of a Section 11113 proceeding. Pilcrow 18n. 401p. At 545n. While we avoided deciding if a claim could be too complex for a Section 11113 proceeding in Frazier, that question is unavoidable here, and it demands that we reconcile the complexity of this issue with the breakneck pace of a Section 11113 procedure. In my view, the answer to this question is dispositive. Pilcrow 265. This case's procedural history proves my point. Despite clear requirements, the district court did not follow Section January 4, 2012 04's statutory timeline for Section 11113 claims. The proceeding below involved two delays that, respectively, violated the requirement that the merits hearing be held within 5 days of the challenge being lodged, and the requirement that the district court issue its order within 48 hours of the merits hearing. 6. Pilcrow 266. The electors filed their challenge on September 6, 2023. Although the question of whether this action should be removed to federal court was resolved by September 14, the district court did not hold an evidentiary hearing until October 30. The majority appears to imply that a status conference on September 18 fulfills the statutory requirement that the hearing be held within 5 days of the elector's challenge. Major Op. Pilcrow 83. However, a status conference plainly does not satisfy the requirement. No later than 5 days after the challenge is filed, a hearing must be held at which time the district court shall hear the challenge and assess the validity of all alleged improprieties. Section January 4, 1204, emphasis added, see Carson, Pilcrow 21, 370p. At 1142, ruling that Section 11113 does not permit a challenge to an election official's certification of a candidate to the ballot, solely on the basis of the certified candidate's qualification, once the period for challenging the qualification of the candidate directly has expired. It is no mystery why the statutory timeline could not be enforced. This claim was too complex. The fact it took a week shy of 2 months to hold a hearing that must take place within 5 days proves that Section 11113 is an incompatible vehicle.
Pausing again for the footnote, I'm just going to say, it seems like the judge is saying, on the one hand, this process isn't long enough, right? And we need, there's language in here with the days, and we have to have so many days and turn it around in so many days. And in order to do a good job, we need more time. So we don't have enough time to do a good job because of the stupid way the law is written. Therefore, we should just let an insurrectionist on the ballot. Or then conversely, we made an attempt to meet the spirit of the law by holding a hearing within 5 days in order to comply with the spirit of the law, but then recognizing that this was too complex, we allowed time for the parties to put together their arguments, with the burden being on the plaintiffs, on the people making the case, to make their point. It's not for the defense to prove itself innocent, right? And so saying, oh, well, we took too long to do this, and that's why we should let an insurrectionist on the ballot. It just seems to me that the problem is with the language, not with what the court did. And they should be directing the legislature to change the language to account for these kinds of claims, because honestly, until Donald Trump, we didn't have to worry about far-right fascist movements getting, enough power to try to overthrow our elections. This is the first time we've had to deal with insurrectionists in federal statute with federal elections since the Civil War. And we didn't, so that's a fault of the legislature, not a fault of the court. But of course, I already think that the decision above just was a slam dunk. So this is you took too long. No, you took long. It didn't take long enough. It just sounds like a Trump argument, and I just don't buy those.
For this claim, the majority recognizes the 5-day requirement, Major Op. Pilcrow 38, but it does not acknowledge the violation of Section January 4, 2012 04's timeline or give consequence to that violation.
Is there any consequence to the violation? I mean, yeah, it sucks, but it would suck worse to make a bad decision that would definitely get overturned, right? Again, you want to have it both ways, and I find that really irritating. Okay, I'll stop now. I've been mostly not commenting this whole time, but I'm just side-eyeing this a lot.
Pilcrow 267. Nonetheless, the majority touts the fact that a hearing was held and lauds the district court's timely issuance of its decision as evidence that this matter was not too complex for a Section 11113 proceeding. Major Op. Pilcrow 84:85, but was the order timely issued? Substantially, I think not. Compare Major Op. Pilcrow 22. The trial began, as scheduled, on October 30th, a Monday. The evidentiary portion lasted 5 days, through Friday, November 3rd, with closing arguments almost 2 weeks later, on November 15th. The court issued its written final order on November 17th. With Section January 4, 1204, the district court shall issue findings of fact and conclusions of law no later than 48 hours after the hearing. Section January 4, 1204 only mandates 2 deadlines, and neither were honored. After all the evidence had been presented at a week-long hearing, the court suspended proceedings for 2 weeks. I find nothing in the record offering a reason grounded in the election code for the interval between the 5 consecutive days of the hearing and the solitary closing arguments. However, I understand the necessity to postpone the closing arguments for one reason: the complexity of the case required more time than no later than 48 hours after the hearing for the court to draft its 102-page order. Thus, while the district court formally, 8. issued its order within 48 hours of the closing arguments, the interval between the evidentiary hearings and the closing arguments was not in compliance with Section January 4, 1204. Pilcrow 268. The majority condoned the district court's failure to observe the statutory timeline by concluding that it substantially complied. See Major Op. Pilcrow 85. This renders the statute's 5-day and 48-hour requirements meaningless. Contra Ferrigno Warren, Pilcrow 20, 462 at 1085, holding that, under Colorado's election code, A specific statutory command could not be ignored in the name of substantial compliance. Gallegos Fam. Props, LLC v. Colorado Groundwater Common, 2017 CO 73, Pilcrow 25, 398 p. 599, 608, where the language is clear, we must apply the language as written. If a court must contort a special proceeding statutory timeline to process a claim, then that claim is not proper for the special proceeding. Pilcrow 269. From my perspective, just because a hearing was held and interveners participated, it doesn't mean that due process was observed, nor should it be inferred that Section 11113's statutory procedures, which were not followed, were up to the task. I cannot agree with the majority that the district court's extra statutory delays and select procedure augmentations indicate that the elector's claim was fit for adjudication under Sections January 4, 12044 and 11113. Contra, Major Op. Pilcrow 81, in short, the district court admirably, and swiftly, discharged its duty to adjudicate this complex Section 11113 action. Dragging. 9. Someone through a makeshift proceeding is not an indication that it was an appropriate process. See Dis. Op. Pilcrow 274, Semmer, J., dissenting. Importantly, the electors were not rushed into the process, they didn't have to file their challenge until they were prepared. Only interveners arguably had inadequate time to prepare. Pilcrow 270. Finally, only a 2/3 majority of both houses of Congress can overturn a Section 3 disqualification. U.S. Const. Amend. 14. Section 3. This remedy is extraordinary and speaks volumes about the gravity of the disqualification. Such a high bar indicates that an expedited hearing absent any discovery procedures and with a preponderance of the evidence standard is not the appropriate means for adjudicating a matter of this magnitude.
Sorry, I gotta pause that. That doesn't make any sense. The fact is, as I've looked into it, Congress routinely waved white Southern rebels back into office. And so it was not an unusual thing, nor was it, what do you call it, extraordinary, or it has magnitude. It has it today because the politics are a little bit different. There's a little less cohesiveness in white identitarianism than there was 100 and whatever, minus 1960s, 1860s. But just because there's a high bar doesn't mean, so what? Yeah, you disqualify them, and then Congress, if they want to, they can put them back on. But just because it's an extraordinary remedy doesn't mean that you can't just do it. People did it in the past all the time without convictions. People did it in the past all the time, so it's just dissent. I'm not finding this nearly as convincing.
C. Frazier, Pilcrow 17 18, 401 p. At 545, holding that inconsistencies between the procedures of Section 11113 and a claim under 42 U.S.C. Section 1983 reinforce the conclusion that not all federal law claims can be raised in Section 11113 proceedings. Conclusion. Pilcrow 271. My opinion that this is an inadequate cause of action is dictated by the facts of this case, particularly the absence of a criminal conviction for an insurrection-related offense.
Not required. Not at all required for it. There's no requirement of a conviction. So if they have engaged in insurrection, that's sufficient. I know it makes your job easier, but just because someone hasn't been convicted yet of a criminal offense, does that mean that they should be able to run again as an insurrectionist? No.
Pilcrow 272. The questions presented here simply reach a magnitude of complexity not contemplated by the Colorado General Assembly for its election code enforcement statute. The proceedings below ran counter to the letter and spirit of the statutory timeframe because the elector's claim overwhelmed the process. In the absence of an insurrection-related conviction, I would hold that a request to disqualify a candidate under Section 3 of the 14th Amendment is not a proper cause of action under Colorado's election code. Therefore, I would dismiss the claim at issue here. Accordingly, I respectfully dissent.
You're basically saying that you have to have insurrectionists, that Colorado is currently inequipped to keep people who would bring down the government off the ballot. No, it's not. You just saw it. You just saw it above. I know you don't like the time frame and that it wasn't quite up to statute, but yeah, there are delays in court cases, and both sides got a hearing, and just this just seems super getting a serial killer off on a technicality dreams here. So I'm just gonna, all right, so this is currently page 11, just some more. Let's see how long this is, because I'm honestly getting kind of tired and I'm finding these less interesting. They're also less important because they might be cited by the Supreme Court in their decision. But again, if it's mostly about Colorado law, all right, I think I'm good. We've been going for what, an hour and a half or something? I'm starting to lose the will to live. So I think I'm going to call it a night there. And we got to hear one of the dissents. If you want to see the other or hear or read the rest of them, you can go ahead and I don't know which screen to show you. I guess I'll show you my big screen. All right. Ooh, there I am. Very cozy, no makeup, chill Christmas day. If you'd like to see the remaining dissents, you can go ahead and download the PDF and do them on your own. But thank you for stopping by and being a nerd with me. I learned a lot, and I don't know if I'll have any questions for the person who gave me an offer, but it might be worth maybe looking a bit more into these dissents and how much weight. Like, I know that there are some technical things that won't overturn a case and some technicalities that will. And whether or not these dissents do a good job of undermining the majority's claim for the purposes of the court is something we'll have to see. All right. I've been Christy. You've been awesome. Have a great day, wherever it is, whenever it is that you are. Yeah, and I think that all that's left is for me to say goodbye. So, goodbye. Mouse isn't going over.